Now this part, I guess, is Mendoza versus Tucson Unified School District. Counsel.
May it please the court, my name is Mick Rusing. I'm here today on behalf of the Tucson Unified School District, TUSD. Before I'd start, I'd like to reserve 5 minutes of my time for rebuttal. There's also a preliminary matter of a blow-up exhibit that we had prepared that I understand there was an objection to, and I was told by the clerks that there was going to be argument, if any, on it. I don't know.
Yeah, all right. Yeah, you may use your exhibits.
All right. Thank you, Your Honor. If you don't mind, you want to set it up?
It might be an exhibit for younger judges. I don't have my distance glasses with me, and that's really hard to read. Could you bring it up closer, counsel?
Sure. And
I just thought these were eye tests when I saw them in the trial court. Okay. This works. Thank you.
What's that? Oh. Well, we have it in front of us, so we
Great. We have this.
Why don't we just take that down, because I can't see deputy clerks here. So.
okay, thank you.
This is the same thing, right?
Yes, Your Honor.
Okay, great. I can see this.
All right, thank you.
Even I can see it.
TUSD is doing everything it possibly can to obtain unitary status, and in order to achieve that, it must do two different things. One is to establish a good faith record of compliance with the unitary status plan that's been adopted, and number two, eliminate the vestiges of prior discrimination to the extent practicable. And we are here today to make sure we're in a position to obtain that status, but we need this court's help, and here's why. As part of this process, a unitary status plan, USP, was negotiated by the parties and the special master and was adopted by the court last year as a roadmap to obtain unitary status by the end of the 2016-2017 school year. Then prior to the USP, in 2012, the parties also negotiated and the court entered an appointment order appointing Willis Hawley as a special master under Rule 53. And one thing that the parties did in these extensive, and then the special master, did in the extensive negotiations leading up to these orders was to agree upon a methodology for objecting to the R&Rs from the special master. And this is where the board was going to come in handy, but I'll refer the court to the lower portion of the handout. Rule 53 provides that the court must give the parties notice and an opportunity to be heard before ruling on a special master's R&R, and provides 21 days for that purpose. And also it provides that facts and law will be reviewed de novo. When the parties were negotiating the appointment order, they expanded it so that the parties would have 30 days for objection and then 20 days for responses, and that would give the special master himself a chance to respond, and then 21 days for replies. And it also permitted public comment during this period. The USP, going across the chart, incorporates the judicial resolution process of this appointment order. And that's the only place in the USP where the special master order objections are dealt with. Now, everybody signed off on this very rational approach, and the court entered it both in the appointment order and by signing the USP. The problem is that's not what's been implemented by the district court. Instead, the first 3 R&Rs were adopted by the court the same day they were filed. Same day. In fact, 2 of the R&Rs were filed as attachments to the district court order adopting them. And one of these orders actually did away with any right to object to the special master's R&Rs, and that was done at the behest of the special master. So the problem we're now faced with is TUSD does not have an opportunity to object as was agreed to as set out in the handout. Secondly, there's no de novo review being conducted as required because definitionally you need an opposition to have de novo review of an opposition. Thirdly, there's no application of the correct standard of review, which includes some deference to TUSD for the plans it proposes to see if they are compliant with the Constitution and USP. Because the standard is not whatever the special master thinks it's best practice from an educational policy or opinion standpoint, but whether or not the plan initially proposed by TUSD on these various issues is constitutionally compliant. And that is not what is occurring here. And all of this is...
Let me ask you something. Am I incorrect in my impression that after you had this initial procedure that the district court modified it somewhat to say, why don't you 2 parties get together, try to work it all out before we get this recommendation? The 2 of you develop something together to the extent you can and work with the special master. And then he will submit an R&R, which will also contain the report on the disagreement between the parties and what each of their positions is. Was that not the way the special master, with the consent of the parties, agreed to proceed?
It's not how the way the parties agreed to proceed, and that's why I did the blow-up, because what they try and do is conflate 2 entirely different processes together. Because the first process, and the one that is addressed in the top of the handout, has to do with plans proposed by TUSD. And the appointment order provides that the USP will develop a timeline for objections to plans developed by TUSD. So then in the USP section 1D1, the parties came up with a thing where the district would submit a plan on these various issues set out in the USP, and then people could object. And then if there was disagreement, the special master could look at it and then submit an R&R. But this was an entirely different process triggered by TUSD submitting a plan, and it was to be exchanges amongst each other. Now, which is entirely different from the R&R being filed with the court and then objecting in court and having filings in court. Because what ultimately happened is the court initially threw out any right at all to object to the special master R&R. And that was in the December 2nd order.
But then that was reconsidered.
It was reconsidered, and then I guess TUSD ultimately was tossed something of a bone, I would call it, where they gave us a, quote, right to object. But in order for it to be a right to object, it has to be a meaningful right to object, and that's what did not occur for a number of reasons. Because what the court did there is said, okay, special master, you do an R&R and you put together the back and forth between the parties, and then you file it. And the initial order of the court said, and there'll be no briefing after that.
But that was reconsidered.
And that was reconsidered, and they allow 10 pages in 7 days.
Right.
Right? And there's 2 more really significant restrictions that were put on it. Number 1 is you cannot raise evidence and arguments not previously submitted to the special master. Well, the problem with that is the special master routinely and on a regular basis submits R&Rs that contain issues and things never before seen.
Doesn't the order allow you to request an opportunity to further object, to file further objection?
Well, it does, but so far all of our efforts to obtain any additional briefing by this court have been dealt with the same no thank you.
But are you appealing the no thank you, or are you appealing, I'm not trying to be glib, I'm truly trying to understand your argument. Are you appealing that, or are you objecting that the revision pursuant to the court's reconsideration order is inadequate? It's inadequate
because there's a couple other components. I'm not trying to interrupt.
No, not at all. I'm just wondering, why is it? Because my understanding is that I read it the way you do, I think, that there was initially not a right to object after the R&Rs were filed. Then you objected to that. There was that motion for reconsideration was granted, and there's this, as you said, 10-day or 10-page, 7-day opportunity, also an opportunity to ask for further opportunity if the need arises. And your position, I think, is that's not adequate. So my question is, why not?
Well, I think it's one, illusory, but secondly, when you combine with another restriction that's imposed, and that is it restricts the parties from filing any evidence of the communications between TUSD and the special master and the plaintiffs, it precludes us from developing any kind of a record. And one of the problems and one of the reasons why the unitary status was reversed 3 years ago was because we did not have an adequate record of what went on below, and specifically an adequate record of good faith compliance with the USP. And this is really illustrated, these points, by the R&R on the university high school admissions plan. Because in that R&R, which we saw for the very first time when it was filed with the court, contained many statements, many conclusions never heard before, we'd never submitted materials on, and then when we object to it, it gets stricken. But a couple of the things the special masters...
That was the one stricken for exceeding the page limits, is that the one?
Yes.
Okay, all right.
But some of the things we put in that would have been stricken because they contained information of communications between USP and the special master. Because one thing the special master said, pointing to the USP, was that the USP required that in developing the university high plan that TUSD work with the plaintiffs and the special master to help develop it. The special master, in its R&R, made a conclusory statement that that did not happen. In the objection filed by TUSD, it was pointed out by affidavit and otherwise that they were in virtual daily contact with the special master for 11 months, sometimes as many as 20 emails a day on this topic.
So why can't you file record of that? Why can't you ask permission to file record of that, a declaration to that effect? What am I missing procedurally?
The court said we can't. The court said, I do not want to see that. I don't want to see communications between the parties. But that is how we establish record of compliance that we need to obtain unitary status.
So you would have to file permission to file that. It's not in the pursuant to the motion for reconsideration.